The Supreme Court will deliver its ruling on an application filed by IEBC Chair Wafula Chebukati on the processing of the presidential poll on Tuesday next week. At the hearing of the application on Wednesday, Chebukati's legal counsel Kamau Karuri told the court that his client is not seeking to lodge an appeal through the back door, but is simply seeking direction on how it expects him to verify the results for the October 26th presidential poll if he cannot make corrections to the statutory forms. Also representing Chebukati, counsel Paul Nyamodi therefore called on the court to clear the way for the chairman to make corrections where necessary.
The Court of Appeal, with tremendous respect to the Court of Appeal, reduced the role of the second respondent to a glorified tally clerk, to mechanically add numbers and declare. Your Lordships found or have directed that the second respondent must verify. The second respondent's understanding of verifying is to ascertain that it is correct. As Mr. Kamau Karuri said when he was on his feet, if it is indeed correct, then there is no problem. However, if for whatever reason there is a discrepancy between the aggregate numbers in Form 34A and the number that is filled in Form 34B, what then happens? There is two situations, or there is two things that could happen. We could go with the direction of the Court of Appeal and leave it for an issue, or leave it as an issue to be determined by the election court, and that is your Lordships. Or it is then possible administratively to correct that arithmetical error. And it is not malicious, as the petitioners would have you believe. It is arithmetics. It is a result of human endeavor. If you add 41,000 numbers, you might get a different result every time. And what the Court of Appeal did in Maina Kiai was then take away from the second respondent the ability to correct even that administrative arithmetical error. So, your Lordships, those are the two situations, and it is the second respondent seeking guidance from the court. And the second respondent leaves it entirely to court. What the court directs, the second respondent will do.
Raila Odinga has, however, opposed the application and through lawyer Willis Otieno submitted that there is no ambiguity in the court's direction, that any discrepancies on the statutory forms should be resolved by the election court. Also representing Odinga, Professor Ben Sihanya added that the Supreme Court cannot assume jurisdiction over the matter as the original jurisdiction for interpretation of law lies with the High Court.
Interpretation, this court has been clear in a recent case regarding the candidacy of Ekuru Aukot. This court clearly said the High Court has original jurisdiction, go to the High Court. And that's what happened. So if they want interpretation, that is the right court. And my lords, my lady, there is no inherent jurisdiction of the Supreme Court of Kenya under the Constitution or under the Supreme Court Act or any other statute.